watch it and we'll hear it. This is a re-agitating of the same issue which has already been decided by this court.
Why did you circulate the letter then? 25. 25. 26, right? No?
25.
There's no letter. Who circulated the letter?
Varinder Kumar Sharma, AOR in this matter.
Nothing. Tell us what it is.
My lord, then may I request for a passover? He is in some family function. I'll try to.
What family?
My lord, I am not aware of. Kindly pass it over. I'll try that he'll join online.
Family function. चाय पीने चला गया.
Grateful.
My lord, sir.
26.
That compassionate appointment if the documents are relevant on the request of the petitioner.
Only
I'm seeking 2 weeks time.
next week, my lord, sir. Date may be.
There is medical emergency.
My lords have dismissed it almost, my lords. Only one request of the.
Yes.
And next week, my lords, any date, my lord.
Next week.
Hello.
Please, Lord. Also, appear for the petitioner. May I just pass?
I'm requesting for a passover, my lords.
Every time this happens, my lords. Either a passover or a request for adjournment.
Yes.
This has been pending almost for 1 year now. They are not filing their reply. No response to your lordship's order that whether they are ready to accommodate the petitioner or not.
Can you accommodating or not?
Usually I don't oppose for adjournment, but then.
For the respondent, private respondent, I have been already appointed.
You are appointed.
And his appointment is subject to outcome of the petition. That is what his appointment letter also says. At times I feel that this is a ploy to prolong the hearing of the petition.
Some problem, Sandeep, in this.
May I just pass over the note, my lords? The Honorable High Court, my lords, in my humble submission, has misdirected itself with the reliefs that I had prayed for.
To you is what they say.
No, my lords, my prayer in the petition, may I request the lordships to come to the prayers of my petition.
Date of 11th of July 2009.
Yes, so that was as per the third amendment.
That may not apply to you. If that doesn't apply, then you.
No, my lords, that's why, my lords, why I said this, that the Honorable High Court has misdirected itself. Would the lordships come to the prayer clause of my writ petition itself, my lords? My prayer was something else. There's no dispute about my appointment from 2003. Even today I am working with them. Never discontinued. So the prayer was from 2003 till the date I acquired MPhil qualification, which is in May 2009, grant temporary approval to my service. And as far as service beyond that is concerned.
Only question is that at the time when you joined also and much later, MPhil and NEET you didn't have. But you acquired before the cutoff date.
Before the cutoff date. That's why my prayer was also different.
But then the rule by which a cutoff date is prescribed,
my lords,
that rule, would it apply to you is the question.
That's why, precisely that is the reason why the prayer clause was differently worded before the Honorable High Court. Since no approval was granted, what happens is this. I am appointed in 2003 by a duly constituted selection committee. There's no dispute about that. The High Court's finding.
What are you working
as a lecturer, my lords.
Computer science.
And for last 20 years, my lords, I have been serving them. Even today, I am serving with them. They are paying me salary. They are deducting professional tax. Everything they are doing. And they still have one post, one sanctioned post available with them. They are not ready to fill that.
The matter will decide it.
My lords, could your lordships kindly have a look at the note?
The education society, the college and the education.
You are supporting him, I think. All through you supported him.
In the
Now don't run away.
we are not supported.
You have supported him. It's your college. Is working for you.
College, we are not supported him. We say that he doesn't have the qualification.
But I thought you have supported him earlier.
No.
There are some letters that you have recommended his case also.
Precisely.
Letters, but
Lords, the stand on record is different and stand before the Honorable Court is different.
Outside you supported, in the court you don't support.
Lords, the most funny part is this. They send my recommendation.
September 2012, page 73, open and see.
Yes.
Proposal. And university also approved him. And also see another letter at page 82. Both are your letters.
Both are mine.
No, what happened? What happened? Why have you taken a different stand? At least the government we can understand. College also dumped him. But is he continuing with you?
But yes, even today, my lords.
Is he continuing with you?
দেখো আসতে সুটকেসগুলো দাও তো ভাই।
এবার কি করতে হবে? ওই বিট্টু স্লিপটায় দেখো না, কোথায় গেল স্লিপটা?
নমস্কার,
হ্যাঁ
আমি জানি ওই স্লিপে কি লেখা থাকে। আমার সঙ্গে আসুন। হুইল চেয়ার, এটা আপনার আর এটা আপনার। স্লিপে শপিং এর কথা তো নিশ্চয়ই লেখা থাকে। একটু পেট পুজোর কথা স্লিপে থাকবে না, এটা হতে পারে?
টিফিন এনেছি তো।
থ্যাংক ইউ।
আরে এই তো স্লিপটা।
স্লিপে তো এসব কিছু লেখাই নেই।
আমরা আছি তো, আপনার স্লিপ।
শুধু ওয়ার্ল্ড ক্লাস এয়ারপোর্ট চালাই না, আপনার ভ্রমণ পথের সঙ্গী হই আমরা। আদানি, আমরা করে দেখাই।
Small bottles, lots of it.
Continued because incompetent teachers can't teach. And you, without unflinchingly, you have supported your taken. But then the issue is, problem is with respect to the college. College makes only, it's a, why is what the
No, yes, what has happened?
grant in aid?
Initially, it was not receiving any aid. So on temporary basis appointment. Now, once they start receiving aid and posts are sanctioned, they don't want to recruit me for obvious purposes, my lords. That is where the dispute starts.
Talking about the college or the government?
The college. Government has nothing to do with it. It is college and university. Now, what happens is this: once the college issues letter of appointment, page 40 of the SLP paper book, it's a duly constituted selection committee. Participated none other than nominee of a vice chancellor, subject expert, home department, HOD of the department, subject expert nominated by the chairman, head HOD of the computer science department, and professor of the education society. So it's a duly constituted selection committee. They don't bring this notice to the Honorable High Court.
All right, complete your argument in 5 minutes.
My lords. Would the lordships have a look at the note, my lords?
Quickly read it.
My lords, so initially, my lords,
Qualified to be
qualified, my lords.
qualified.
No, not in 2003, my lords. That is why, my lords, I'll take your lordships to my prayer clause as well. Petitioner is duly qualified to be appointed on the post of assistant professor in computer science, having passed Master of Computer Applications and MPhil on 22/5/2009 in subject. 8/7/2003, the respond number 3 university sanctioned 13 posts of lecturer in computer science. 6th of August 2003, Joint Director of Higher Education, Aurangabad, granted permission to fill up posts on permanent no grant basis as per the advertisement approved by the university. On 23rd of August 2003, respond number 4 published an advertisement with which applications were invited for 13 posts of lecturer in computer science along with other subjects. On 7th of October 2003, the university had also made available Vice Chancellor's nominee in computer science at page 38. Then on 7th of October 2003, the duly constituted selection committee carried out the selection process on 7th of October 2003 and selected petitioner for the post of lecturer in computer science. 8th of October 2003, on the basis of selection by the duly constituted selection committee, petitioner was appointed as lecturer in computer science. However, the said appointment was on temporary basis as the petitioner had not passed MPhil examination. From 2004 to 2008, thereafter the petitioner was continued in service, video orders dated so and so. May 2009, the petitioner passed MPhil examination. Cutoff date is of 11th of July 2009. Acquired necessary qualification for permanent lecturer in senior college. On 4th of April 2012, 4 seats or posts for the subject of computer science in respond number 4 college were brought on grant in aid basis by the government. On 6th of August 2012, principal of respond number 4 college submitted all the necessary documents to the General Secretary of Sri Saraswati Society. 8th of September 2012, the respond number 4 submitted the proposal to the respond number 3 university requesting grant of approval. Then on 5th of February 2013, respondent university raised certain queries with a letter dated 5th of February 2013. On 12th March 2013, university granted approval to the appointment of the petitioner temporarily for the academic year 2003 and 4. Then on 1st of November, the approval and everything continues. 7 December 2015, Marat's principal also requests the university to grant post facto approval for the appointment of the petitioner for earlier academic years. Then Marat's I file a petition. So cause of action. So the cause of action to file the petition, Marat's, was not my discontinuation or anything. The cause of action was that as far as earlier services, please grant me temporary approval, and the day on which I acquired the qualification, prescribed qualification, please grant my appointment a permanent accreditation to my appointment. So it was a very reasonable prayer, and therefore a consequential relief that my salaries in accordance with that may be calculated and paid to me. That was the limited relief. My lords. So petition was filed and then pleadings are complete. Then during
answer the objection raised against your appointment by the High Court. Where is it gone wrong according to you?
My lords, yes. Page.
Court judgment, just tell us where
Yes.
it's gone wrong.
No, my lords.
Because single judge allowed your case, High Court says a reverse.
No, my lords. It's only before the division bench.
Concurrent.
No, there's no concurrent. My lords, in Bombay post 2011, we don't have LPA. Lords, we are on item 27. This is SLP Civil 25482 of 2024. So I'm sorry.
Yes, you are right.
Yes.
So as from the High Court judgment.
My lords, yes. So, my lords, to sum up the Honorable High Court, my lords, there are 5 points which are against me held by the High Court.
Yes, tell us.
Number 1 is that the initial appointment of 2003 is not by duly constituted selection committee, which is contrary to record page 38. Nominee of the Vice Chancellor I have brought to your Lordship's notice.
Constituted.
Yes. So page 38 is the nomination by the Vice Chancellor, and page 40 also reflects that it was a duly constituted selection committee. Now these documents, they are not controverted, my lords, also before the Honorable High Court or here before your Lordships. So it was a duly constituted selection committee.
That's the first question. Second, what is the
Yes. Second is sign on the order of appointments. Now, my lords, the Honorable High Court says that all the appointment letters are signed by the principal and not by the society. Now, my lords, in my humble submission, I cannot be held responsible for that. Now, they do not initiate any prosecution or any kind of proceedings against the principal or the then principal who was. And they don't dispute my continuation right from 2003 till 2025. So, my lords, in my humble submission.
third point?
Yes. So, the third point is, my lord, deficiency is not cured. Saying that the deficiency.
Deficiency, which deficiency?
Yes. No, my lords, the deficiency was that once a proposal was forwarded by the principal to the university, that was on 8th of September 2012, he writes back on 5th of February 2013 and raised certain queries, which is at page 76-77. Now, my lords, I could not lay my hands on it being a private party.
Yes, what is the deficiency they allege?
My lords, for a minute, my lords. May I take your lordships to page number 76 for a minute? Whereas the deficiency which is there at number 2, the report of the selection committee,
Not signing deficiency.
not signed by the chairman or secretary of the institute
Your
again.
argument is same. That's not you. You are not the established.
I can't be held responsible, and
What's the
and
fourth? What's the fourth?
it's only just to
Seeking approval, non-production of
now.
resume.
Could your lordships, only for a minute, could your lordships come to page number 78? I'll answer that also without any document. This third query, page 78 is the answer. Notice that this deficiency, your lordships may kindly see the letter in reference. So this is to the principal addressed by the university on 12th of March 2013. The deficiency is answered. SB Society, that is reference SBSC, that is SB Education Society, 12/13/904, later dated 18/2/2013. There was a compliance by the college. They don't place it before your lordships for perusal and appreciation. Then what's fourth was delay in seeking approval. Now again, my answer would be the same. Now if the principal is writing them only in 2011 and 12 and seeking my approval of my services from 2003 onwards, I may not be held responsible for that. Till then they are paying me.
All that is argued, but core question you are not arguing. I could put against you the fact that the rule requirement that you should pass the test before the cutoff date
My lord.
is something which was applicable to, not applicable to you.
Yes. Now, my lords, could your lordships come to my prayer clause in the petition, my lords?
Because those rules don't apply to you. How do you answer that?
My lords, could your lordships come to page number 100 for that? Prayers in my writ petition. According to me, in my humble submission.
Your argument was not that before the cutoff date you passed the exam. Your argument was that there was a duly constituted committee, you were properly selected.
Yes.
And the selection process was not over. They were duly sanctioned posts. It was subsequently filled despite your availability and your selection. This all is arbitrary.
Yes. And in addition to it, I am not seeking any undue benefit or undue advantage. Kindly come to page number 100 of my petition. Relief is very reasonable. As far as that service which I have rendered from 2003 to prayer at page 100 in the writ petition. May I read, your lordship, at page 100, paragraph number 23. By a writ of mandamus or any other appropriate writ or order or directions in the like nature, the respond number 3 university be directed to grant permanent approval to the appointment of the petitioner with effect from his passing MPhil examination. So that is 2009 onwards.
Then shall we say that your permanency in your appointment
From 2009 onwards.
will be, when did you pass?
That is May 2009.
2009.
May 2009. That date is 22nd of May 2009, which your lordships will get on in point number 1 of my note.
22nd May 2009.
22nd May 2009. And the cutoff date is 11th July 2009. And what was the further part of the same relief?
Appointment was when?
Temporary appointment is of 2003, 23rd August 2003. I'm sorry, 7th of October 2003. The process started in August. 8th of October 2003 is the letter of appointment.
When was granted? Selection committee's proceedings.
That is 7th October 2003, page 38. 38 and 40. 7th October 2003. Point number 5 and 7 of my note, my lords.
23rd of August 23, advertisement to the selection process appointed. And he was appointed in 2020. Point of time.
No rejection, no discontinuation, nothing. No, that's why, my lords, I said it was a very a reasonable request made to the Honorable High Court, my lords.
And you are being continued also.
And I am being continued even today. And my lords, only one thing to add. As far as the respond number 5, Mr. Adgaokar's client is concerned, my lords, his appointment, Mr. Adgaokar's client, respond number 5, his appointment is concerned. That has happened when SLP was filed before your lordships and notice was issued. Nonetheless, the appointment letter itself mentions that his appointment is subject to outcome of this petition. So, I don't think he can seek any equity if at all it comes to that.
Why are there limited number of posts?
There are 5 sanctioned posts
Why are posts are vacant, your lordship? As their own contention is that the posts are vacant over there.
Direction can be issued then to the university.
In 2023.
You are for the university.
Malas, I am for the state.
Who is for the university? Or is it an admitted fact that there are posts?
It's not an admitted fact. The university was hearing before.
Some posts have arisen for consideration. 4 posts in April 2012, 4 posts have created.
Could your lordships turn to page number 11 of my IA that I have filed? It's a document issued by them under Right to Information Act. That one post is still vacant.
About the post.
Malas, so I would like to make a submission that the recruitment was made on a temporary basis, Malas. Thereafter, there was no sanctioned post at the, back at
No,
that
we
point
are
of
not
time.
saying about recruitment or what not recruitment.
Malas, the UGC net qualification was also.
Advertisement was for 13 posts.
Yes.
On the basis of advertisement, the selection process was undertaken on 7th of 2003. By which time we didn't have MPhil and the required qualification, but then you appointed him temporarily, and that he passed on 22nd of May 2009, and then the rule actually enabled people to be regularized if they had passed the examination by 11th of July 2009 in any event of the matter. Under which circumstance, when you are continuing him in service, there is a question of not granting a direction to the effect that he has prayed for.
Malas, there was a notification issued by the UGC net that the qualification that were required.
We are passing an order today. He will say from the date he passes the examination, he will be taken into account.
Malas, there is a financial constraint on the state's part as well, because there is a GR that has been issued back in the 2018. If I may just, it is in Marathi, Malas, if I can just render it.
Pass orders.
Malas, if my GR can be considered because there is some financial constraint.
Sorry, your GR.
There is a GR issued by the state government because there is a financial constraint, Malas, if that can be also taken on the record, Malas. I'm sorry, Malas, it's in Marathi.
Sins are committed before the GA.
No, I don't know.
Correct. We will allow your petition with effect on so and so date.
That is acquiring qualification, your lordship.
Lordship may not direct it to be treated as a precedent. Because they may be.
Why? They have been properly selected.
Right, Manoj, but similarly placed candidates without qualification will also seek similar relief.
We are-
Your Lordship may have a look at
We
page
are
120.
regularizing him with effect from the date he gets qualified.
That's right. Your Lordship may see the High Court has found.
Only thing is, Sandeep, अगर आपको यहाँ से दे देते हैं May 2009 पेंशन मिलेगा?
That slightly would be an issue.
Then you go to the court again for reckoning the past period.
But if today your lordship turn down that,
When will he retire? We will also say that his past services will be accounted for pensionary benefits alone.
very well, Malas, very well, highly obliged.
Malas, there is.
We will not disturb you.
Malas, there is already a financial constraint that has been showcased by the GR, Malas. Therefore, we were not able to accommodate, Malas.
Can't drag on matters like this.
Your Lordship, the High.
This is not the way we treat our teaching staff here. What respect we have. He's a professor. How many students they will turn out year after year, year after year. If this is the way we respect our teachers, what future do we have? He's not an ordinary worker or anything. He's a lecturer. States have no concern about teaching professors. For 20 years. 20 years he's been teaching. And how many hundreds of students he would have taught? And if he's not competent, throw him out in no second. But if you think he is capable, then respect him at least. We'll allow this.
Obliged lordships. The lordships would be directing appointment to be permanent, made permanent. Matters. Highly obliged. Lord.
Letter है? Why?
The
respondent
there was some medical, I mean,
some
he was not
medical
well or
evidence.
something.
Next week?
Yeah.
Next week.
Great.
Much obliged.
Mate, please.
Fine.
Short and neat issue of law, my lords. There are conflict of views between Madras and Delhi, Kerala. Madras and Delhi have taken a
time.
sorry, my lord.
What's the fan?
No, this is 29A application for extension filed by us. They participated fully, my lord. The parties in between were negotiating for a settlement. Both the parties write to the arbitrator, a district judge arbitrator, my lord. Both the parties write to him that we are talking settlement. After that, my lord, we report that the settlement, the extended, when the extended time is about to close, we report that, my lord, the settlement has failed. The arbitrator had closed the cases for arguments.
Time expired in February 24.
24, and after 3 months,
Not
the award
yet
was,
passed?
after 3 months, my lord.
Oh, after the time expired.
Yes, my lord. Nobody, in fact, my lord, none of the parties, my lord, it escaped attention that it had to be moved for extension. Then the award was, my lord, in our favor, after which, my lord, he filed a 34 in which one of the grounds raised was this
Award
extension.
can you?
Sorry, my lord.
Before or after? It's all right. But
Yes, 29A, kindly, my lord, your lordship may take 29.
29A, not after award.
No, no, it says, my lord, that's elastic, my lord.
Not elastic. Not elastic.
Lordships have dealt with this provision in Rohan also, my lord. Yes.
After the award, what? There is a
Lord, what happened is,
so
by conduct,
arbitration act.
29A, Lord,
After
the award resulted in our favor, my lord, after which he filed a 34. In 34, one of the grounds was this. In between, my lord, we filed an application under 29A for an extension. That application, my lord, by the impugned order, while dismissing, the court dismissed the 34 as well, my lord, without leaving the scope for any other objections.
The short point is,
Yes.
tell us after the award is passed, can it be condoned?
Yes, my lord.
Show us that.
There are certain judgments, my lord, these issues have been.
Section first.
Let me read the provision, my lord, 29A.
Before or after
The award,
expiry, it doesn't say.
my lord, I'll read the whole provision, my lord.
29A.
29A, this your lordship will find.
The award is there, read that. The award
Was in
matters
2015,
other than
yes.
international-
The award in matters other than international commercial arbitration shall be made by the arbitral tribunal within a period of 12 months from the date of completion of pleadings under subsection 4 of section 23, provided that the award in the matter of international commercial arbitration may be made as expedition. That's not relevant. Then 2, if the award is made within a period of 6 months from the date the arbitral tribunal enters upon the reference, the arbitral tribunal shall be entitled to receive such amount of additional fees as the parties may agree. 3, the parties may, by consent, extend the period specified in subsection 1 for making award for a further period not exceeding 6 months after the 1 year, my lord. Then 4, if the award is not made within the period mentioned in 1 or the extended specified under 3, the mandate of the arbitrators shall terminate unless the court has either prior to or after the expiry of the period so specified extended the period, provided that while extending the period under this subsection, if the court finds that the proceedings have been delayed for the reasons attributable to the arbitral tribunal, then it may order reduction of fees of arbitrators by not exceeding 5% for each month of such delay. Provided further that where an application under 5 is pending, the mandate of the arbitrator shall continue till disposal of the said application. Provided also that the arbitrator shall be given an opportunity of being heard before the fees is reduced. Then, my lord, the extension period referred to in subsection 4 may be on the application of any of the parties and may be granted only for sufficient cause and on such terms and conditions as may be imposed by the court. While extending the period referred to in 4, it shall be open to the court to substitute one or all of the arbitrators, and if one or all of the arbitrators are substituted, the arbitral proceedings shall continue from the stage already reached. The award has been passed also, my lord, and they filed a 34 on this ground as well as the other grounds also. Now, my lord, because the award has resulted against them, they continued not through the award proceedings also without raising an objection.
There is no award in the eyes of law.
No, my lord,
If
I will
it's
just.
passed beyond the.
No, that is not a direct consequence in that is what Rohan also says, my lord, the object and reasons of this enactment is to just see, my lord, how, my lord, the shortest possible time, the award is to be pronounced and the parties are not relegated to court. Let me just read, my lord, from Rohan onwards. My lord, there are certain judgments.
How many judgments are there? How many judgments are there which have taken the view
Yes.
that award can be passed even when the
Kerala, my lord. Kerala High Court has taken the view. Supreme Court, there are no judgments today directly on this issue, but there is a judgment in Rohan which says you can file it even after the extended period is over because the provision. Yes.
can file. To that extent, you are right. In fact, our judgment is also there.
Yes, your lordship judgment, Ajay.
Expression is either prior or after the expiry of period specified therein. The words are very clear. It is not prior or after the passing of the award.
But my lord, it is.
Just to read it.
My lord, it's elastic.
Application
It's
or extension of it.
Yes.
We're not against you. We are just testing the.
Yes, yes.
If we accept your proposition, it will be saying an application for extension can be filed prior or after the making of the award. That's what you want us to read.
Yes, my lord. Because your lordship will see, and my lord, in the.
So what are the judgments on the part?
Yes, my lord. Now, first, I will read Rohan, my lord. You've given the.
Rohan is Supreme Court.
You've given the coup. Yes. Yes. Judgment. Yes. No, எனக்கு கொடுங்க.
Who's observing? No, sir.
Yeah. Yes. One is 2024 SCC online Supreme Court 2494, but this will be
2020.
2024. This is the citation. SCC online Supreme Court 2494.
Okay. Read the relevant portion.
Yes. This is also. Yes. Para 2 to 3. Yes. Or the views given by. This was the question was mirrored in para 2. Can be filed after the expiry of the period for making the award. In which not certain paragraphs are relevant.
Question in para 2.
Para 2.
Read that.
Yes, yes.
Question how they formulated.
This common judgment decides whether an application for extension of time under 29A of the Arbitration Act 96 can be filed after the expiry of the period for making of the arbitral award.
Not award.
Yes.
Period for making.
Yes.
It's not after the expiry of the award.
Yes, Minod. That was, in this case, it was filed before the award. But, Minod, the considerations in some paragraphs are relevant, Minod, in this. Yes. Because the interpretation and the Law Commission report, everything was considered in.
Portion which you want to rely on.
Sorry, Minod, portion.
Read that portion which you want to rely
yes.
on.
Para 6 onwards, Minod.
Which are those paragraphs which will indicate that applications are maintainable even after the.
Yes. Not kindly see para 6, Minod. 29A4 is the provision which requires interpretation. It states that where the award is not made within the specific. Sorry, Minod.
1 minute. After the period specified.
This is the Law Commission report. 14, no?
हाँ बोल बेटा करण। क्या?
जिंदगी की रोज की दौड़ में हम अक्सर चीजें भूल जाते हैं,
अंकल।
पर अच्छा लगता है जब कोई आपका ख्याल रखता है, जैसे कि आरबीआई ख्याल रखता है आपके अनक्लेम डिपॉजिट्स का।
अनक्लेम डिपॉजिट मतलब?
वो बैंक खाते जिसमें 10 साल या
T24 application extension is filed on 20th of September 24.
Yes, in between award was passed.
Award passing is irrelevant. The moment you say award is passed, it goes completely against you.
Not, I
You
want
want to even make that argument. Passing of an award is impermissible under the law.
not that.
If you say that point, then it will be disastrous because there is a prohibition under the act to pass an award after the time is expired. Only provision is that the time can be extended. If we accept that time can be extended, he will pass an order. We don't take cognizance of an award
Yes.
because it cannot pass an order after the time is expired.
Yes.
It doesn't even in equities help you if you argue that.
Yes, yes. It is on our application today, on extension application.
That's the only argument you can make.
Yes, Lord. Lord, in fact, what was to be,
Just because award is in your favor, that doesn't make any difference.
no, just because my award is in my favor only, this objection has come in the 34 itself. They have not even not pointed it out when the case was pending and the arbitrator gave 2 dates thereafter to pass the award. Lord, I want to show, my Lord, the sequence, my Lord, of the events of this case, which may have a bearing in this particular case actually. My Lord. Can I just pass on a short,
Why? What's the
the list of, yes.
prejudice
Dates.
part
Where
of
is
it?
my list of dates?
You're arguing on prejudice, is it?
Sorry, my Lord.
You're arguing on prejudice and equities.
They've not objected, they've consented impliedly. That also, as in one of the judgments, they say if the party with their eyes open have allowed the arbitration proceedings to continue, they cannot turn around and then object later on in 34. Not that this is a ground that the award was related.
They attended proceedings.
They attended, my Lord, they never raised. They never raised. In fact, my Lord, parties were talking settlement and they have sent mails to arbitrator that we are talking settlement, we are settling it. And after this, my Lord, we informed. Thereafter, my Lord, none of us pointed out that the time was getting expired. So therefore, in that context, Lordship have said in Haryana board, my Lord, as SSCB, that, my Lord, in party by conduct, waive. Also, my Lord, there are certain paragraphs in the Rohan itself. And Kerala, in is whether reasonable explanation.
The delay, which was the delay?
Yes, no. In
You
I gave a list. Yeah, can you give him a copy?
The question is a wrong question.
Yes.
What you formulated is the wrong question.
Yes.
Say that once an award is passed, whether time can be extended or not.
Yes.
That's a wrong question. That's the reason, that's the error which High Court also committed.
Yes. And my lord, they have dismissed the whole 34 also in toto. In fact, in one of the cases, no, my lord, there are other objections if possible, but
We can't even touch it. If
we
the
can't-
time is not extended, he's right to that extent.
extension, whether it could be granted or not, is the only question which the court could have done. Whether the award is honest or not, my lord, whether that could have been declared in that is another point, my lord.
Can be declared.
Also, whether they could have replaced the arbitrator and whether that at that point of time somebody else could have taken charge from that time onwards.
Yes, that's a,
Hmm?
that is obvious. Consequence, he's right. What is the doubt about it? He's saying the period of 12 months. The arbitration shall terminate. Obviously, he's right.
Yes. But I will just read.
Not necessary. These
Yes.
are not. Choose those dates, Mona.
Yes.
From dates from 22nd, 24, you no,
Yes,
other
Lord.
dates not necessary. 20th of February,
No, 20th October
the
23.
time expired. After that, you read.
Yes, my lord. Please
The
come to
4th March, there is some date.
4th March. There was, in fact, not the parties were talking settlement.
Tripartite agreement.
So 8th March, my lord, arbitrator was informed. Sorry.
That the notice for pronouncement of it will be given.
Yes. On 9th of April again, arbitrator informed that the award is reserved. Then he took time on 27th April to pronounce the award till 11th of May. It is on 11th of May, the award was pronounced.
Operative portion of our share.
Before that, my lord, two dates if I can show. On 1/11/23.
He shares it on WhatsApp. Huh?
Sorry, my lord.
Class, understand.
Yes, yes.
Operative portion he shares.
Sorry, my lord. Yes.
No.
After the award. No, just two dates in the first page, my lord.
When did he give the award? Why only operative portion? All very mysterious. He realized that time has expired.
No, not
So he's
because of.
passing on operative
No,
portion.
this
to
is about
WhatsApp.
certain guarantees and the bank documents, the payment, some timelines. Therefore, my lord, operative portion was shared. Timelines were there because the bank documents had to be cleared and we had cleared the mortgages. So therefore, my lord, you paid the huge amount and cleared all the mortgages in pursuance of the agreement. But if your lordship may see in the first page on 1/11/23. 2010-23 minutes. In fact, written arguments got over on 15th of September, on 22nd September. Then on 20th of October 23, during the pendency, matter was referred for clarification when counsel represented that talks were in progress.
Answer lies in section 29(4), my lord. If the award is not made within the period specified, is not made, time will be extended for extending the time. And the
Award expires. So therefore, you are right. So therefore, the arbitrators mandate is terminated. That's the correct point.
Yes. And then my subsequent section says, your lordship can see reduce the
It will
fee.
be dead. Arbitration is dead by that time. There's no arbitration.
Yes. And my friend's question,
Whether arbitration can be revived or not, it can be revived.
award is set aside, they can.
There's no award.
Yes.
There's no award.
They can start a new, because what happened was the section 34 petition was allowed subsequently, setting aside the award. By the.
There is no award, sir. Where is the question of setting aside the award?
It was declared as an award. Therefore, a court has to say it is not an award.
No award. Can't be declared. Once the time is expired, he can't declare an award. So there won't be an award because arbitrator's mandate is terminated. When his mandate is terminated, where is the question of an award?
If passed an award, that has to be challenged. Therefore, I challenge by way of 34. And my friend's question is answered.
But then the point is that there is a power to extend.
Power to extend, not
Power to extend. Forget about award. You are getting confused with the award, both of you. There is no award. The act doesn't take cognizance of an existence of an award when the time to make an award is expired. So if there is no award and the time has expired, what is to be done? Court has the power to extend. Court can, in a circumstance, extend before or after the date of expiry. If they extend, arbitrator will pass an award. If they don't extend, it is over. Matter ends there. So therefore, the question is
Yes.
whether we can today. Well, the High Court has said no.
Yes.
But there is a power to extend. So on facts of a case, suppose we come to a
The
conclusion.
Delhi High Court is directly on this point. What happened was my friend is saying there are two decisions of Madras High Court setting aside the award, holding that after the period is over, award is liable to be set aside, remanding parties to go for relegating for fresh arbitration.
They're all on.
There are two decisions of the Delhi High Court.
On 34.
Sorry, Madras
they're
High
all-
Court.
yes.
There are two decisions of the Madras High Court on 34, setting aside award and then asking them to go for fresh litigation, whatever they want. Then, my lord, there is one decision of the Delhi High Court in Chandiak Missionaries where the Delhi High Court said it can be done. Then, my lord, a subsequent decision of the Delhi High Court in Power Grid Corporation, identical facts, after the award is passed, the petition was filed, then that Madras High Court was followed, and the Chandiak decision was held to be not a proper law. There is only a stray decision of the Kerala High Court in RKEC project. It can be done. Views of Madras, Delhi supporting one view, RKEC, Kerala High Court holding that yes, it can be done. That is the issue which my friend is raising.
What's your stand?
My stand is not the award, the district court is perfectly justified in setting aside the award. There is an award named under the Arbitration Act. It has to be set aside
How
by
is an award defined? How is an award defined? Arbitral award means an interim award. Includes interim. Nothing more.
It's a
Okay.
decision on merits of the matter.
The facts, what do you say? Expired in, time expired in February.
Yes. After I filed my 34 petition only, they realized that the period is over. Then they filed application before the High Court. After reading my 34 petition. Until then, they were not aware.
It's no different, but how did you file? So therefore, you also assume that there is already an award.
Yes.
Yes, it was brought to me. Then I read it. Yes, there was an award. What are all the grounds which can be challenged? One
You
ground,
withdraw your 34 matter ends there. There is no award.
34, my lord, the district.
There is no award.
No, 34 petition was ordered by the district court. 34 petition was.
You should. Sorry, confusion. Lawyers make so much out of nothing.
But extension, if it can be granted, there's one suggestion, my lord, is there is another option as well, my lord. Of course, Rohan says when it terminates, please don't terminate it abruptly. All the discussions are there when the proceedings terminate. Like your lordships are perfectly right on saying that the difference is between whether to see it as an award or whether it is only an application, whether it could have been permitted. In this case, my lord, the High Court ought to have seen whether we have made out a case for extension, whether the reasonable delay has been.
That's the only question.
That was not considered. That was not considered. That was not even gone into, my lord. All it said was go into all other judgments, Kerala, Madras, High Court, Delhi, and then said, no, this is award is this, so award is set aside. So therefore, my lord, your lordship may consider an extension.
Madras,
And not- the parties have gone extensively on evidence, etc.
They have gone into the court, misled themselves.
Yes, it's a wrong issue which has been decided, my lord.
Law with regard to this aspect has to be clarified by the Supreme Court.
Clarifying? What we said is the law.
Therefore, let RKEC has to be.
Kerala judgment
Law is
is-
also what is not to be said. Very
sometimes.
important aspect of law is what is not to be said unnecessarily is law. They have gone into all sorts of inquiry, red herring.
Yes.
Simple that there is an award only when it is made legitimately. You will not say award made after expiry is illegitimate. You don't should not say.
Yes.
Patently illegal.
You should not say what
Can't
is
be.
not,
No,
what
if it-
law should not be said.
Yes, my lord. Patently.
An award which is passed within the legitimate period is an award.
Yes. Therefore,
You
it
should not say that the award passed after the legitimate is not an award, not necessary.
may I say this.
So therefore, there is no award.
May I say this, my lord? An award was passed after the mandate is terminated is an award which is patently illegal.
Litna padega na.
Very well. Lord, I have handed over
Only one submission.
just a compilation only for the purpose of this thing.
You just write 3 pages order.
Very well.
Only one.
Very well, ma'am.
Only
Deeply
one?
obliged.
2 pages if possible.
Very well.
Only one submission, my lord. An award which was passed after the mandate is over is a patently illegal award. If it is a patently illegal award, section 34 can be set aside. That therefore, my lord, the district court was perfectly justified in setting aside an award which is patently illegal. It's a patently illegal
No,
award.
no, that 34 was challenged in
patently illegal
37 and the High Court said, let this case be decided, so come at the
Patently
appropriate
illegal
stage.
award. It has to be declared by
No,
the
no.
court.
Wait,
Sorry,
I cannot ignore.
wait till we pass an order.
very well.
I cannot ignore.
Only for the completion, we have produced all the judgments that my friend referred and what I am relying on.
We'll tell you what we're going to do. There's no mystery in it.
Yes.
You supply to us the other judgments which have.
I've given a
It's like
compilation.
Everybody is falling into that kind of.
I have given, my lord. This contains every judgment. This contains your lordship judgments, Ajay Protect on reasonable cause also, my lord. The second one is that, my lord. The Rohan, my lord, will have the law commission. I'll give the paragraph numbers.
Okay, you tell us what they are.
Yes,
What is the first
one is Rohan, my lord.
First one is Rohan.
Rohan is the first one where it says the elasticity that an application can be filed after the extended period also. That is, I am also telling the paragraph numbers if your lordship may
Not
see.
necessary. Then
Yes, my lord. 1014 will be relevant. Then the next is your lordship judgment in Ajay Protect, my lord. That is on sufficient cause, condemnation, that application under 29A, sufficient cause to be shown and therefore it can be condoned. That is your lordship judgment, not sitting with Justice Sandeep Mehta.
no, doesn't matter. So
Yes, no, I'm just saying the issue. Then Ashok Kumar Gupta,
you say
is in that.
sufficient cause.
The third one is the,
1 minute.
sorry. Para 16 of that. No, para 16 of your lordship judgment in page 22. Lordship may say,
But we said
yes.
that arbitration's remedy is very narrow.
Ah.
So therefore, 29A must be liberal.
No, this is also saying that Rogan says so, my lord. Para 10, para 14.
Statute incorporates party autonomy even with respect to conduct and.
Lordship will see, which one your lordships are having, not the page number.
Accordingly, so the consideration of the-
I'll give the para numbers, my lord. 10, 11, 13, 14.
Therefore, sufficient for the operation.
What it says is sufficient cause and termination is defined. 14 is relevant, my lord, in Rohan. And the next judgment, my lord, in the serial item A2 is Ajay Protect. In that, my lord, lordship may note, my lord, in Ajay Protect, the para number, my lord.
You've seen it. What is the third?
All right. Third is, my lord, the Kerala judgment, which is in our favor on facts as well, my lord, which says that it can be extended, my lord. After award, it can be extended. Sufficient cause and extended, 24 to 29 of this compilation.
Next.
Then, my lord, your lordship will find Satyam.
Madras.
Yes. Therefore, only for, it was a 34 case, my lord. Yes.
So yes or no, what does it say?
Yes. It says, my lord, that it, though it extends, it says no.
Can't be extended.
Can't be
What is the-
extended after award. So,
Even the next Madras is also no.
that is what the impugned order relies upon.
That's-
Justice Asha's judgment, page 33, my lord.
All right, then what?
That is Surya Dev, my lord. Then your lordship will find another interesting judgment is Ayasami, where my second argument of implied consent has been dealt with at page 61, my lord.
Supreme